Hello everyone, this is Neha Pellegrino, Senior MSP Compliance Counsel, and I wanted to take a moment to welcome you to the ECS on MSP podcast. As you all know, ECS is dedicated to assisting you navigate all the complexities of MSP compliance, but we believe that compliance shouldn't be static. The rules evolve, technology evolves, and the way people consume information evolves, which is what led us here. While we've been continuing to connect with you through our monthly webinars, which we love providing, we recognize that this industry moves really fast, and so do the professionals working in it. So the idea behind the podcast is about meeting you where you are by delivering content in a way that fits your schedule. And we're really excited to have this be a part of our ongoing commitment to share knowledge and support you. Each episode will bring you practical insights and real-world discussions, all in a format that's easy to listen to and easy to learn from, almost like you're sitting on the couch in our office. So whether you're here to stay compliant, deepen your understanding, or just hear from the voices that live and breathe this work every day, you're in the right place. That being said, let's get started. Great, thank you. Good afternoon. So as our webinar title indicates, today's session takes a deep dive into concepts surrounding liability claims. MSP compliance discussions tend to center around workers' compensation, but liability claims present their own unique risks, obligations, and considerations. So our goal here today is to provide you with a plan of action regarding these claims. Going through today's rundown, we'll start with an overview of liability MSP compliance. Then we'll walk through must-dos in terms of Section 111 reporting, as well as some recent updates to the user guide. We'll discuss the conditional payment process and how this process can differ slightly with these types of claims. And lastly, we'll provide you with pre-settlement strategies as we go through a checklist of items to take to the settlement table. Of course, time permitting, we'll also take any specific questions that you all have and answer them live here this afternoon. So let's jump right in and have Marty break down some policy background.
Thanks, everybody, and thanks, Neha, for passing it along to me. So we know that a lot of folks on this line have probably done something with regard to Medicare compliance, but because it's liability, you probably are, maybe in need of a little bit of a 201, just to kind of give everybody the framework that they need to understand, okay, where do I go if I really want to know where this obligation originated? Or some lawyer is asking me a question, well, how do I cite what the obligation truly is? Where do I find the authority? Things like that, right? So the background of liability Medicare compliance is a little bit different from workers' comp. Liability has only been around since as a Medicare secondary payer concept since 1980, and the Medicare secondary payer statute was actually passed to help support that, to create the foundation for what we know today as Medicare compliance in the liability context. So it's grounded in federal law. There is a detailed regulatory framework that really underpins really everything that you need to do, in addition to the policy guidance that also exists. So what are the foundations? First of all, we've got our legal authority, right? So there's the citation right there, 42 USC 1395 YB. And then there's also regulations that can be found at 42 CFR 411.20. Now, obviously, these have been around for a long time, many of them. In fact, a couple of them have just been recently updated around penalties. But these obviously provide the background and really the teeth for Medicare, and have given us a lot of pain over the course of the last however many, 35 years, right? So the goal really in everything, whether it's the law, whether it's the regulations, whether they're the policies, is that Medicare only pays to the extent that no other primary payer out there exists who is either required or responsible. So this is going to apply in liability, group health, it's going to apply in no-fault claims, and it's going to apply in workers' comp. And so we're focused today primarily on the liability and to a degree no-fault. There's a little bit of no-fault that we'll talk about as we get into this. Now, there are a couple of things that you need to think about when you look at the Medicare secondary payer statute. Every single thing that happens has one of two different aims. First, coordination of benefits. The goal is to try to determine who ultimately is the primary payer. Is it Medicare, or is it this liability settlement? Is it Medicare, or is it this auto carrier, right? So that's the first goal. It's a coordination of benefits goal. The second goal is to recover. So Medicare is able to get money back, conditional payments, the payments that Medicare makes all along while the claim is pending. Once that claim goes ahead and settles, Medicare is able to get the money back. So the goal for everything that we see and we'll talk about today is either to determine who's responsible to make the payment, and then ultimately if Medicare does make a payment, gets Medicare the money back. And the most obvious and the most often way that folks in the liability realm encounter Medicare is actually Section 111 reporting, right? So this is largely policy-based, but it is the law, right? So the law is that you have to do something, but the policies tell you how to go about the process of the doing of the something, right? So that's where we call it Section 111. The NGHP user guide is our primary source document that governs liability claims reporting. So if you just think about it from the perspective of, I need a resource, where do I go to try to figure out what I'm supposed to do? It's probably in one of those two things. It's either going to be in the statute, the regs, or it's going to be in the non-group health plan user guide. So we can go on to the next slide and we'll start to get into some of the fundamentals and what those fundamentals look like when it comes to a liability claim. So the three core obligations that apply, these apply in every single case, whether it's liability, comp, or no fault. And the failure to meet any single one of them can result in significant penalties. Now, those penalties are either going to be direct civil penalties where you're going to have to potentially repay Medicare, or they're going to be more like operational penalties, right? An operational penalty is, hey, we didn't do this one thing, and then now, years later, we're dealing with this situation where there's a lawsuit, or now years later or months later, we're dealing with the situation where this individual who we settled with is saying, hey, that their Social Security check has been cut off, right? So it's either an operational penalty or it's an actual civil penalty. But the three requirements of all MSP compliance are: one, you have to first identify Medicare beneficiaries. This is a really big problem in liability cases, and we'll get into how we go about doing that. It's different in liability, obviously, and it's different in no fault, obviously, than it is in workers' comp. So any claims payer must determine whether or not a claimant is a Medicare beneficiary or could become one before any payment attributable to a personal injury settlement can be made. So you got to determine, hey, am I paying a Medicare beneficiary, yes or no? Now, that might be not possible in every single liability case, right? We know this. So there's some framework where Medicare sort of gives you a get out of jail free card. Maybe it's not that free, but we'll get into that later on. The second thing is, if Medicare has made some payment, then it must be repaid, right? So if Medicare is paying for injury-related medical care that's clearly related to the underlying accident or injury, and then later on the person receives a primary payment, Medicare must be fully reimbursed. They have to be fully reimbursed dollar for dollar, not just a pro rata portion of the injury claim, right? So if Medicare paid $10,000 worth of treatment and the individual receives $11,000 from an injury settlement, Medicare can take $10,000, even if that $11,000 is really only, a small percentage of what the person ultimately could have recovered had they gone to trial. And then the last, that's conditional payments, and those are typically done prior to settlement, right? You're hopefully trying to resolve them at settlement, but you're trying to identify them prior to settlement. Then the last thing is timely and accurately reporting the claim. So once you've made a payment on an injury claim, then you have to notify Medicare timely and accurately through Section 111 mandatory insurer reporting. Failure to do so, that's where you could have significant civil penalty. Now, the odds of you getting hit are low, but if you are hit, it could be potentially quite catastrophic. So you want to be timely and accurate when it comes to reporting any claim or any settlement, rather, to or on behalf of a Medicare beneficiary. So that's where we are with our basics of this. We're kind of through our 201 section. I'm going to turn it over to Lou now, and Lou's going to remind us all about one more important item, which is Medicare Advantage.
Thanks, Marty. Let's go to that next slide there. You do have obligations. Everyone knows that you have those Parts A and B obligation. You have to look into conditional payments and make sure that Medicare is paid back if they do make conditional payments on those cases. However, you do have further obligations when it comes to Part C or the Medicare Advantage plan. It's commonly known as the Medicare Advantage plan. It's a private insurance company offering to use or pay for Medicare items and services. All of these plans provide the standard Medicare benefits, and they include additional coverage such as dental insurance, vision, and hearing. And approximately, and it's not enough that almost half the country Medicare beneficiaries are utilizing Medicare Advantage plans, but about 1 million people a year change from plan to plan, making beneficiary verification an ongoing necessity. When we looked at the numbers from the past 15 years, back in 2007, there were about 8 million people on a Medicare Advantage plan. It's projected to be 35 million in 2026 as a result. Conditional payment obligations do apply to these plans, and I think it's important to think about that as you're going through. It's not enough just to say, oh, I got a conditional payment letter from Medicare. I also need to go and get a Medicare Advantage plan. And that doesn't matter if you're settling a liability claim or a workers' compensation claim. You do need to address Medicare Advantage plan conditional payments. And why does this matter in liability and no fault? Because the private cause of action exists for any party that's involved. So if I'm a Medicare Advantage plan out in, let's say, California, and I want to be paid back, I don't have the Department of Treasury at the ready. So I have to use the private cause of action. I have to sue for double damages. It's not the same as the way Medicare handles these issues. However, you do, as one of the payers or an entity that receives payment, you can work directly with these Medicare Advantage plans to address anything that is out there. Moving on to that next slide. I think it's important to talk about Section 111 and two seemingly innocuous lines that come from the statute itself. The entire mandatory insurer reporting framework rests on just two subsections of 42 U.S.C. 1395Y. The plain language is deceptively simple, but the compliance obligation is substantial. So it's important to dive into these and look at them in a way to figure out what Medicare is actually saying in this. So with 42 U.S.C. 1395Y B8(1), responsible reporting entities must determine whether a claimant, including individuals where the claim is unresolved, is entitled to benefits under Medicare on any basis. So that's what Medicare is looking for. They want you to figure out who in your system, which of your claims, whether it's liability, no fault, PIP, if it's workers' comp, they want you to determine which of the people you're dealing with are either on Medicare or eligible for Medicare under the statute. And number two, part two, if that claimant is determined to be eligible, then the responsible reporting entity must submit the required information to the secretary in a form and manner specified by the secretary. That's your Section 111 framework. These two lines generate the entire world of Section 111 reporting, from identifying who your Medicare beneficiaries are through reporting that settlement in the form of a total payment obligation to claimant submission. Both steps are mandatory. These are not discretionary. And for the most part, companies are doing this. We do see it from time to time where it's not happening, but that is happening few and far between now. But those are your two obligations: identification and reporting that information. Let's go on to that next line. Next slide. So Neha, the first part of this is determining whether a plaintiff is entitled. What can you tell us about how companies can go about doing that?
Yeah, so thanks, Lou. In order to run a search to determine Medicare status, we need 5 specific query elements known as the Big 5. So we see them here listed: first name, last name, date of birth, gender, and either social security number, last 5 digits, or the MBI there. Once that information is received, that data can then be matched against the Medicare database to confirm beneficiaries. So we know what information we need, but how do we go about getting that information? So if we can go to the next slide, one of the issues that we run into is that we can get some resistance from plaintiffs or plaintiffs' counsel when requesting this data, specifically regarding the Social Security number, as that's protected information, and so naturally there's privacy concerns there. But obtaining these specific data elements is necessary to comply with our reporting obligations, right? So what can you do? Well, we could utilize CMS's model language, which is essentially a form letter that explains the need for that information, as well as spells out exactly where to find that information on one's Medicare card. And not only that, the form also provides space for the individual to certify a refusal to provide the Social Security number. And now you may be thinking, the whole point of sending the form was to obtain information to comply with reporting, so why does the refusal matter? But it matters because CMS has established a safe harbor for these situations. And that regulation is referred to as the 2-in-1 rule. So Lou is going to take us through the steps to demonstrate compliance under this rule.
Yeah, thanks, Neha. So when a beneficiary or when a claimant or their representative refuses to provide identifying information, Medicare has provided this safe harbor, but it requires documentation on your part. It's a multi-step, good faith effort. And when you follow this to the letter of the law, claims are not subject to penalties where you have demonstrated the following. So the 2-in-1 rule is basically this. You have to ask 3 times for the information. Think about it like that scene in Austin Powers where they have to ask Will Ferrell something 3 times before he answers correctly. This first one has to be written communication. You have to send 1 written request. That can include emails explaining the need for Medicare information. As Neha mentioned, you should consider the Medicare model language form to establish that formality and clarity, the limited scope of why you're asking for such personal information. Number 2, you have to ask at least 1 time through regular U.S. mail. This creates a documented paper trail separate from just that electronic communication. So that's twice. I've now asked for that twice. The third way, it can be by phone or other means, and that other means can be a 3rd time in writing. You must make at least 1 additional attempt by telephone or other means. Log that information in your system, the date, the time, the outcome of the call. Make sure that your claim file does this, and then make sure that you keep those efforts on file for 5 years. The 2-in-1 rule requires 3 total attempts, 2 of which are in writing, 1 of which must be that formal written request by U.S. mail, and at least 1 other method for that. Now, here's the thing. If at any time, let's go to that next slide. Documenting your efforts. So meeting this request prong is only half the requirement. You must document what your good faith efforts were, so that way you can log a defensible compliance record. And once you have made the required attempts, you've received no cooperation, the following steps apply. Number 1, you've received no response. So you sent those 3 methods. The claimant attorney or the claimant themselves provides no response at all. So after those 3 required attempts, you have satisfied the good faith effort standard, and you are protected from any civil money penalties that could potentially happen on that. The other way this could happen is if you get a clear and unambiguous no. They have refused, the claimant or the claimant's attorney has outright refused in clear and unambiguous terms to provide that required information. This will also satisfy the good faith standard. But again, just like everything else we've done up until this point, you must document that effort. Retain all of your efforts in the claim file, the dates, the method, outcomes of each contact attempt, and maintain that documentation for a minimum of 5 years to ensure that it is available in the event that you are audited at some point down the road. Let's go on to that next slide. Here's an example of that model Medicare model language form, it does talk about the limited scope of why you're asking for this information, what you're going to do with it, and you should use this as one of your attempts, whether you email this to them or you mail this to them when you send that written documentation through the U.S. Mail. Go to that next slide. So Marty, we've been through the documentation part. Let's talk about step 2 in submitting information to Medicare and ORM versus TPOC.
Yeah, Lou, and I think it's important to emphasize that if you satisfy the 2-in-1 rule, it doesn't matter if you know the person is on Medicare, you just can't get the information from them, you can still go ahead and settle that case. Your goal is to document your efforts to identify whether the person's a Medicare beneficiary. If you can't get their Social Security number, their MBI, or the last 5 digits of their social because they refuse to provide it, you do not have to worry about settling that case. That was a regulation. That's why we call it the 2-in-1 rule. That was a regulation that was passed, I should say, was really put into practice by Medicare to make it so that people were actually going ahead and settling cases with Medicare beneficiaries who were just, for whatever reason, afraid to give out their Social Security number. Why? Because they're counseled oftentimes, but they shouldn't be doing that, right? So certainly it's a really important thing to document. If you don't already have a plan in place for that, think about it today, right? But when we get to step 2, now you have the information. Now you know the person is a Medicare beneficiary. Why? Because they've provided you their social, you've performed that monthly query that Neha was talking about, and that query has returned this person's a Medicare beneficiary. So once a person is confirmed as a Medicare beneficiary, you have 2 different obligations. Now, what's important from a liability perspective is understanding that ORM is almost always no. In liability cases, ORM is almost always no. In no-fault cases, ORM is almost always yes, right? So if you have a situation where there's a blend of liability and no-fault involved in your particular case, just be mindful of that, right? But in a liability case, it's almost always no. And why would it be no for ORM? It would be no because of the fact that you're not presently assuming or presently handling any ongoing responsibility to pay for medical benefits. So a person's going to send you their medical bills and expect you to pay them. You have ORM equals yes, right? That might happen. That will happen in a no-fault case, right? If I get involved in a car accident today and I'm a Medicare beneficiary and I go to the hospital, my car insurance, my no-fault coverage is paying for that. Now, when you do have ORM, you should be careful and understand that it's only for claims that are being paid on an ongoing basis. It's not just, hey, send me your bills and I'll send you a check and then we'll resolve this whole thing right away. It's a situation where you're paying for medical treatment on an ongoing basis. If you do, you want to report the ORM equal to yes. You want to report the ICD-10 codes. And then when you do that, that will tell Medicare, hey, over here, we're responsible. Marty Cassavoy and his team are responsible to pay for Lou Porrazzo's ongoing medical coverage as a result of his car accident. Like, that's how ORM works. Now, obviously, in a liability case where you're dealing usually with people after they've had an accident or injury, and you're settling all their claims all at once without paying for any ongoing treatment, you're not worried about that. So most of your claims are going to be ORM equal to no, as I mentioned. What you do have to worry about in liability cases, way more, and in almost every liability case, is the concept of TPOC, right? So what's TPOC? It stands for total payment obligation to the claimant. So the CMS, Medicare just comes up with these fancy acronyms. Nowhere else do you find TPOC. What TPOC signifies is any settlement that is resolving in whole or in part a claim for medical benefits. So the person may have claimed medical. You may think it's completely specious and something that you should not be paying for, but you're still releasing that claim. You have something to report from a TPOC perspective. Any settlement that exceeds $750 with a Medicare beneficiary must be reported. You're going to report the ICD-10 code associated to that accident or injury or alleged accident or injury. Here's the thing. it's the alleged accident or injury, right? It's going to apply both in liability and comp cases. It's going to rarely apply in no-fault cases. And you're also going to report the date and then the amount, right? So, and it's important to understand, too, that TPOC date is going to typically be, in a liability case, the date that the release is signed. If there's no release, for whatever reason, it's the date of payment. Now, the most important thing on this entire slide is that bottom one. Late initial reporting of either ORM or TPOC may result in civil penalties. Timely action upon confirming the Medicare beneficiary status is not optional. It is a legal obligation. You must, if you know the person's a Medicare beneficiary and you've settled that case with that individual, you must report that claim within 1 year of the date of settlement. So if I settle my case today, I have until basically next May to report that claim to CMS. That gives me plenty of time. There's no reason why I shouldn't be able to do it within a year. So we're going to go on to the next slide, and I'm going to briefly cover ORM primarily in no-fault claims, and then Neha's going to go really deep on TPOC in liability claims. When it comes to ORM, tips and tricks for no-fault claims. This is important for the no-fault folks in the room. You know, we kind of cover it on the comp side. It's a little bit different in the no-fault side. So, accurate, timely reporting, obviously this is what's important. You want to make sure that you get the correct information reported initially, and then you also want to make sure, and this is critical, that you timely terminate. So let's start with ORM. The idea behind ORM is that it must be presently assumed. It's to be reported whenever medical responsibility is something that's currently accepted. It's not what's expected in the future. It's what you've currently got going on. So what I tend to think of, and I know that Medicare gets all aggravated when I say this, but it's that if you're going to rubber stamp a bill that comes in and you're just going to say, yes, we're going to pay that one, we're going to pay that one, we're going to pay that one, assuming that it's related to the underlying accident or injury, then you have ORM. If every bill that comes in, you're just going to put in a pile and say, we'll deal with this later, you don't have ORM. Right? So you think about like that clerk who in the old days would have just paid it, right? Paid it. That's ORM. Now, in no fault situations, once you either have reached a policy limit, right? So let's say we have a situation where you've got, you know, a $10,000 no fault coverage, right? Once you've hit that $10,000 in payments for that person and you're no longer responsible, report ORM termination. You also should report the policy limit amount, right? So oftentimes your system will automatically take care of some of those things, but once your policy limit is reached, you need to report ORM termination. You can also report ORM termination if you determine through investigation that the claim is actually not yours, right? So you start by paying for the person's medical treatment, and then, you know, $5,000 into a $10,000 policy limit situation, you realize, wait a second, this is not ours. Well, you could report ORM termination in that circumstance. You should also report ORM termination when you're no longer responsible due to the time lapse, right? So claim's been open for 3 years and your policy lasts for 3 years, you should report ORM termination in that situation. The reason why you want to do that is because you don't want ORM, or you want ORM termination, and the reason why you want to terminate in that situation is you don't want ORM-Y lasting forever, even though your claim is not actually being paid. Why would you say that you don't want to report ORM-Y forever, even though your claim is not being paid? There's no reason that you don't get penalized for being late to report ORM termination. CMS only penalizes you for late initial report of ORM. However, this is where the operational penalty comes in. Because if you haven't terminated ORM and you're not responsible for an individual's medical coverage, then guess what? When that person goes to the pulmonologist, when that person goes to their cardiologist, when that person goes in to Sloan Kettering to have their cancer treated, and their coverage is goes through the payment system at Sloan Kettering, for example, they're going to look and say, hey, wait, we have a claim with the Marty Cassavoy Insurance Company for you. You should contact Marty Cassavoy and he'll make payment here. And the person says, wait a second, this is cancer. This is not my car wreck. Well, doesn't matter. you had the opportunity to terminate. Now, there's a way to go about dealing with that, and you can get that resolved, but the fastest, easiest way to do that is to terminate ORM timely. Now, in some states where there are large dollar limit policies that can go on for a very long time, for example, like in Michigan, right, where we still have lifetime PIP, lifetime no fault in a lot of ways, right, in a lot of cases. The 525 rule, which was enacted by CMS, is available, right? If 5 years have passed without any treatment and cumulative payments on medical are less than $25,000, then ORM may be terminated even in an open-ended situation. So like if you're in Michigan and you've paid, $14,000 on a claim and you haven't seen anything from the person in the last 5 years, you could terminate ORM. ICD-10 codes, very important. These accurately identify the accepted injury. This can also lead to basically incorrect situations where CMS is saying, hey, you should go to the Marty Cassavoy insurance company instead of making payment because you've over-reported ICD-10 codes. Our recommendation is always report the one code that most closely approximates the actual injury the person suffered. And as I mentioned before, late initial ORM, that's the penalty. Late initial ORM. The operational penalty is you failed to terminate. You messed up because you failed to terminate. But the penalty that you could see from CMS, the potentially catastrophic one, is you didn't report the claim in the first place. That's what you want to avoid, situations where you haven't reported the claim in the first place. Okay, so that's ORM. We covered that for no fault. Far more critical for liability folks, of course, is TPOC. And so I'm going to turn it over to Neha, and she's going to cover our TPOC tips and tricks.
Great, thanks, Marty. I did, before moving to TPOC, I know we were just talking about ORM, and again, most liability claims are ORM no, but if you're talking about claims where you do have ongoing responsibility for medicals, there was a recent update to the user guide that allows for ORM to be terminated for any other reason not prohibited by the insurance contract or applicable state law. So that update just allows for great flexibility as far as other grounds for terminating ORM. I know that it expands further, stating that an insurer's refusal to accept ORM or continue to accept ORM is a valid termination reason. Again, going back to as long as it's permitted by the terms of the contract or applicable law there. So just wanted to touch upon that before we move on. So we'll go through what encompasses a reportable TPOC here with some TPOC tricks and tips, I guess. So first, TPOC is reportable when you are releasing medicals. So if there's no medicals being released, there's no reporting obligation. Also of note, it's important to document the terms of the release for accurate reporting. And that brings us to our second bullet. Now, when you have a liability claim that meets the criteria for an NOINJ or no injury diagnosis code, that claim does not need to be reported. This is somewhat of a newer update as well, where these are the types of claims where there's no associated physical injury involved. The user guide states that while it's no longer required to report these types of claims, it is optional that the RRE can report the record with a no injury diagnosis code. So I think, given that it's not required, our take has been that, to avoid unnecessary no injury submissions, that, we just recommend focusing on actual reporting requirements for injury-related claims there. Okay, number 3 is the total settlement amount. So what's included in the TPOC amount, right? The TPOC, the computation includes everything from your total settlement, if there's medical expenses, attorney fees. So just remembering that this amount encapsulates the total payment obligation and not just what the plaintiff receives. And then as far as the TPOC date, so I know Marty touched upon this a little bit, but the TPOC date is the date the payment obligation was established. So that would be, the date the the settlement was signed or the release was signed. In states where there's a court approval that's required, the TPUC date would actually be the later of the two, either the settlement agreement or the approval of that agreement. And then where there is no written agreement, TPUC date would be the date the payment is issued. And then going further into that, it would be the date of, first payment where there may be multiple payments issued. And last but not least, we know that late reporting can impact penalty exposure. So, with CMPs kind of now active, the timely reporting of TPUC post-settlement is extremely important. Okay, so I think we can move on to our next topic, where Marty will guide us through a recent policy revision regarding wrongful death settlements.
Yeah, thanks, Neha. And this question is something that we've received quite a bit of over the course of the last few weeks, just because CMS only recently made this update. And the update actually has created some uncertainty, because it used to be very clear that CMS really just didn't want you to report, or it looked like, I should say, maybe it wasn't so clear, that CMS just didn't want you to report wrongful death claims. And CMS has changed that. So I'll just read the new policy. It's only a couple sentences. So it says, in order for the wrongful death theory of liability to preclude Medicare from recovering from a settlement, judgment, award, or other payment, complete documentation must be provided that shows the claimant what was claimed and released or had the effect of being released. Additionally, a citation to the appropriate state statute or case law that precludes recovery from a wrongful death settlement should be included with any such dispute or appeal. Wait a second. What's that second sentence? That second sentence has nothing to do with Section 111 reporting. That has to do with conditional payments. What is a conditional payment sentence doing in a no-fault, or a NGHP user guide, which is supposed to only deal with Section 111 reporting? So basically, what changed here? CMS omitted language previously that previously indicated that payments entirely under wrongful death theory are not required to be reported. So they took that out. It used to say if the claim is only under the wrongful death theory of liability, it shouldn't be reported. The new language is focused on the documentation requirements for disputing conditional payments, not on the reporting obligations directly. That's important. Now, what they're saying is, when you go ahead and file an appeal or dispute on a conditional payment that might exist following wrongful death, you want to provide citation to the state statute or case law precluding wrongful death recovery. Honestly, this is really frustrating, right? Because at the end of the day, the most important question in all of this isn't whether or not you're recovering or not recovering, or CMS is recovering or not. The question from a Section 111 perspective, and where this should have lied, is the following. Does the settlement release the claimant or decedent's medicals? Person died. They had medical prior to their settlement. There's a claim that was made. There's a settlement that occurred with next of kin, with the estate, with, whomever, with Sammy Sosa. It doesn't matter who the settlement is with, but it's over a dead person, right? So the person has unfortunately died, passed away. They had medical treatment up until that point. Are you releasing their claim, or anything that would have happened, or that they may have had, or that the estate may have had around medicals that they've paid, right? They may have unpaid medical bills that are supposed to be resolved by the estate. Are you releasing those? Yes or no? If the answer is yes, you're releasing those claims for unpaid medical bills, then you have a claim to report. If the answer is no, you're not doing that. You're paying the person for their loss of companionship, right? You're paying the next of kin for their loss of companionship. You're paying the estate for the loss of earning power, whatever it is, but it's not related to medical, you don't have a claim to report. It just comes down to that. Are you releasing medicals, yes or no? And so this is not that different from the prior guidance that we would have said before they had changed the policy in the first place. But this is important. I want to make sure that we focus on this. This is the number one question that we've been getting from liability folks over the course of the last month. I'd say that I get one of these every other day. So I want to make sure that we had some time to focus on it. You may have questions about it now, and we can get to them when the Q&A comes around. So with that being said, we're sort of through Section 111. And now it's time to come back to Neha, and she's going to walk us through the lien obligations, conditional payments, and all of that good stuff when it comes to liability cases.
Sure. So if we can move to the next slide. Great. All right. So conditional payments, I think just a brief rundown, conditional payments are payments made by Medicare for services where another party is the primary payer. And conditional payments can be made by traditional Medicare or Medicare Advantage plans or even Part D plans. So here we have a very, classic timeline. You have a Medicare beneficiary where an injury occurs. That person goes and gets treatment where Medicare ends up paying for that treatment, conditionally, of course, upon being reimbursed. There's a claim that's opened, and then settlement of that claim, and hopefully discovery of any of those, Medicare liens pre-settlement, so that Medicare can be reimbursed, and there aren't any surprises which come along later. So, it's also important to have your conditional payment letters or CPLs reviewed to ensure that only claim-related treatment is listed, and if not, that you file a dispute for those unrelated charges. The primary grounds for disputing liability conditional payments are generally relatedness due to that grouper algorithm that Medicare utilizes, which consistently pulls all services. On the next slide, we can go a little deeper by identifying some key points surrounding conditional payments. The first one here being the signed consent. So for liability claims, the beneficiary is the debtor. It looks like did we lose the slides, or is that just me? I can just keep going through, but the beneficiary is the debtor, so we would need a signed letter of authority from the plaintiff providing consent to gain access to CPLs. There we go. Or a demand. However, where no such authority exists, the beneficiary themselves will still receive a CPL. So, plaintiff's counsel or other representatives can still obtain a copy of that letter. Not to mention that authorized entities can access conditional payment amounts and copies of CPLs through the Medicare Secondary Payer Recovery Portal for traditional Medicare liens. So let's talk about the fixed percentage option. That we don't, we can go back one slide, thanks. So this one we don't see used that often, but it's great if it applies to your case. It allows for an alternative to resolving a recovery claim by paying 25% of the total settlement amount instead of following the conventional recovery process. There are specific criteria here. So the claim must be related to physical injury. The total settlement amount must be less than $10,000. The Medicare beneficiary must elect this option, and that should happen pre-settlement, as well as, Medicare cannot have issued any demand. So a convenient option if the criteria fits, but it's also good to just have an overall awareness of what the conditional payment amount is prior to selecting that option, just, in the event that you actually end up overpaying as a result. So let's move to the next one here. Okay, so what if same slide, next bullet. So if you have someone that is on Medicare Advantage, is it possible that they could also have traditional conditional payments? Bottom line here is yes, that is possible. It's possible to be on both Medicare Advantage as well as Medicare. So, it's important to coordinate with the Medicare Advantage plans early, and also to determine, which party is going to be taking responsibility for these liens. And that hopefully those are discovered again pre-settlement, because we can see either private cause of actions come through from Medicare Advantage plans, or we can see demands for conditional payments come through post-settlement. So getting those tied up prior to finalizing your settlement agreement is always really important. And then the last item here on this slide is in regards to obligations. So direct payment to Medicare can be made by either claims payer or by the plaintiff or plaintiff's attorney. Although it's preferred that the claims payer fulfill that obligation. And really this is because if payment isn't made, Medicare does have the right to switch the debtor and pursue payment from any party to the settlement for recovery. So you can't simply sign away, declaring responsibility when it comes to those payment obligations. So, okay, now we can move on to the, so it looks like we're just going to round out today's discussion with Lou as he goes through a checklist of items to take to the settlement table.
Thanks, Neha. And when we're talking about liability, the settlement is really when most of the MSP obligations converge. Having a checklist of what to do prior to that settlement ensures that no compliance obligation is overlooked. It ensures that your exposure and every party's exposure is clearly defined before you execute that release. So number one, remember, address the Medicare status. If the person's not a Medicare beneficiary, state that in the release. Say, we've investigated, we've complied, this person's not a Medicare beneficiary. If they are a Medicare beneficiary or you cannot obtain the information to determine that they're a Medicare beneficiary, remember the 2-in-1 rule, remember the documentation portion of the 2-in-1 rule. If the claimant is confirmed not to be a Medicare beneficiary, or they will not provide you with that information, or they just go ahead and ignore you, document your file and make sure that that's part of it. Number two, be proactive. There shouldn't be any surprises at the time of settlement. Identify conditional payments before you settle. Medicare in liability has a one-time only collection effort, so it's important to get that amount as early as you can. Work with the other side. If you're on the RRE side and you're working with a plaintiff's attorney, ask for a copy of the letter. Ask if they've filed a dispute of that letter if it came out. Ask them if they want you to do that, so that way you can get that amount to the lowest number possible. Establish clear rules around what the reimbursement obligations are and the contingencies, and who is responsible for paying back to Medicare. If anything, make sure that's in writing. Make sure that's part of your settlement. Number three, articulate the Section 111 reporting. And remember, a lot of plaintiffs and plaintiff's attorneys don't really understand what your obligations are under Section 111 reporting. Quite honestly, some of your own attorneys might not understand what your Section 111 obligations are. So clearly state in your settlement documents why you asked for certain information, what the limited scope of why you're asking for that, and what you're going to do with it. If you have to explain the difference between Section 111 and conditional payments in that, please do so. And then include the TPOC amount and date on that, so that way when you go ahead and you report through your Section 111 platform, you're doing so in a way that is in conjunction with what you put into the release. And then number four, this is something that I always try to recommend: obtain a waiver of the private cause of action. Seek this, especially when a Medicare Advantage plan is involved. The plaintiff attorney indemnification is legally ineffective. Do not rely on that to substitute for proper MSP compliance at the time of settlement. So see if you can get that. If not, make sure that every party is doing everything that they should. Moving on to that next slide there. Marty, why don't you take it away and wrap this up for us?
Sure. We'll go to the 5 key takeaways, and then we'll get to some Q&A. We've got tons of questions. So first up, think Medicare compliance first. So Lou just talked about that. Definitely, as soon as your claim comes across your desk, just assume that the person could be a Medicare beneficiary. And, you want to make sure that you're actively identifying them as such. And if you can, obviously document that 2-in-1 rule so that you can go ahead and pay that claim quickly. It's important to understand. The 2-in-1 rule doesn't require you to do it in any particular order or even any number of days. You can do it all within the course of a couple of weeks and be taken care of. Second thing, the 2 aims of the MSP, coordination of benefits or recovery. That's everything that they're trying to do. It's either try to get you to make the payment properly or to get the money back from you. Do not overlook conditional payments. there's somebody out there on your claim system right now that has Medicare Advantage plan that you don't even think about. That Advantage plan, a couple of years later, they could wind up suing your organization if you go ahead and settle that case and don't properly identify and investigate that Medicare Advantage conditional payment. So please do so if you haven't already done so. And if you have any questions about it, you can obviously contact any of us. Timely and accurate reporting. It's important to understand that in the liability context, the most important thing to report is the TPOC, date, amount, and make sure that that's done within 1 year of the actual settlement. And then lastly, wrongful death claims. Again, this is the number one question that I've been receiving the last month or so. The big question for you is, are you releasing the decedent's medicals? If no, then Medicare recovery is precluded and you don't have to report the claim. If yes, you need to report the claim to CMS and via Section 111, but either way, you want to document your file accordingly. So we do have some time for questions. I don't know, Adrian, if you want to kind of go through them or if you want me to kind of go through them, it's really your call.
Yeah, I'll go ahead and ask you some questions. So the first one is from Natisse. The CMS user guidelines had defined no fault with broader terms than found under a typical insurance policy, so that it also includes general liability medical payments coverage. Is that still correct?
Yeah, so I can take this one. The user guidelines or the user guide and no fault, generally speaking, is very broadly defined in the under federal law. So under federal law, no fault would be anytime when you're paying for medical coverage as a result of an incident that occurs on the property or premises of the insured. So there are some crazy stories or crazy policies that can ultimately be determined to be, quote, no fault coverage by CMS. Generally speaking, it's going to be, not only a it's either going to be a car accident, right? Property or premises of the insured would be property coverage where there's an accident, right? So you've got homeowners coverage and there's an accident that occurs and you're paying for medical as associated with that. And then the other part of it that I sort of omitted by accident was in the use or operation of a motor vehicle. So anything where you're paying for ongoing medical treatment in those circumstances. Basically, anything where it's not comp and you're paying for ongoing medical treatment that could have been anticipated as a result of the particular policy. General medical payments are not considered to be no-fault coverage, right? So medical insurance is not no-fault coverage. Also, supplemental accident insurance is not no-fault coverage.
Great, thanks, Marty. The next question is from James. What can you do when medical information is insufficient for an adjuster to identify the proper ICD-10 code?
This is a good one for our panel, I think, right? So what can we do when you can't tell from the medical information to identify the proper ICD-10 code? So just personally speaking, we tried, like we said, to pick the one code that most closely approximates the complained of accident or injury. However, it's important to understand that you have to actually know that the person was injured in order to be able to report the claim. That's a requirement that CMS has, right? So ORM, for example, is not required to be reported until you know that the person's actually treating for it's your understanding rather that the person's actually treated for an injury. Neha, Lou, certainly if you can't figure out what the injury is, it would seem that you probably don't have anything to report if you don't have any medical or anything like that, right?
Yeah, I think
Right.
you can.
Yeah, I mean,
you
I
can
think
rely on the.
Oh, go ahead. Go ahead, Lou.
I think you can rely on the 2-in-1 rule. Chances are, if you're not getting what the medical issue was in the demand that they made, you're not going to get the Social Security number. So document your efforts to try to get this information so that you can comply with the statute. If your 3 attempts go unanswered or they clearly and unambiguously declined or say no, then you are in compliance. Keep those records for 5 years. What were you going to say on that, Neha?
Yeah, no, I think that's great. That's all great tips. And I think the other thing too, I don't know if it's coming down to maybe a disagreement about what's actually being released, just making sure all of that's within your settlement agreement and kind of making sure that you discuss, communicate, and finalize, what ICD should be listed and what's actually being released as being accepted and agreed upon as part of the settlement agreement.
Thank you for listening to this episode of the ECS on MSP podcast. We look forward to joining you next month for our next episode. For the latest updates and educational content from ECS, please visit our website at examworkscompliance.com. See you next time.